Hello, everyone, and welcome back to One Civil Law, where we learn through the misfortunes of others. As always, I'm your host, on Civil Law, a licensed attorney in both Texas, Virginia, and before the United States Supreme Court, who, when I remember where the mute button is on my system, sometimes records videos about legal cases that are happening in your world and in our great country. And today's case brings us to a friend of mine, a good friend of mine, Nate, the lawyer, Nate Brody, who had filed a lawsuit against Christopher Bouzy, and the case was dismissed, which is very, very sad for many of us. So we're going to try to look at this and see what the judge has to say and try to assess it as best we can as we try to assess the court's reasoning. Of course, I note here specifically that Nate is my friend, so I'll try to adjust for that accordingly and trying to assess things in a neutral way. But maybe I can only assess so much, or maybe I can only correct so much. So I'll try to correct and remain neutral. But, you can judge for yourself how well I'm able to actually accomplish that objective. All right. So we are in the District Court of New Jersey, Federal Court, on a motion to dismiss. Before the court is the defendant's motion dismiss, the plaintiff. Complaint for failure to state a claim. Subject matter jurisdiction is proper pursuant to rule. Venue is proper pursuant to rule. The opinion is ordered without oral argument. For the reasons below, it's granted. Which, fine. If you can decide it on the papers, you can decide it on the papers. Fine. All right. Background and history. Plaintiff is a former university police officer of the city of New York, a member of the New York Bar, a former Bronx County assistant district attorney, and former law school instructor who creates and opines a YouTube channel under the name Nate the Lawyer. Defendant is the chief executive officer of Sentinel, a New Jersey corporation that purports to fight discrimination and harassment on Twitter. Well, they used to anyway, until he got booted off Twitter, which, was a nice shot in Florida, but I digress. Plaintiff is or was a resident of New York, and defendant is a resident of New Jersey. Plaintiff's YouTube channel, which was founded in 2014, has approximately 255,000 subscribers. Court needs to update its number. It's like 70,000 more than that now. Way to go, Nate. And has attracted millions of views. It publishes pre-recorded videos as well as live streams in which viewers watch a video program in real time with the option to participate in running stream of commentary that's visible to all participants in a chat window shown next to the video. Viewers can pay to have their chat comments rise to the top of the chat window or stay pinned to the screen for certain amounts of time, making it more likely the host will respond to them. Popular live stream hosts can generate significant income from these paid elements and other monetization mechanisms offered by YouTube. So far, so good. Then we have, I guess, a finding from the court. Is this a legal finding now? Plaintiff is part of an informal group of experienced lawyers with law-oriented YouTube channels referred to as LawTube. Is that a finding now? Is LawTube officially legally a thing? Have we been declared a thing by a court? So this is scary. Who knew this? Who live stream legal commentary and discussion, often appearing on one channel as a group. Yeah. Among other content, LawTube hosts have live streamed sensational trials that were video recorded for public viewing, including criminal trial of Kyle Rittenhouse and the defamation trial between formerly married celebrities Johnny Depp and Amber Heard. The popularity and revenue generated by these law streams depend in part on how potential viewers perceive the host's experience, professional knowledge, and above all, credibility. Well, I think that's true. I think that people view this channel, hopefully, in particular, because they view my knowledge and credibility as particularly high, and trying to give honest assessments and trying to give that knowledge. So yeah, your perception of my knowledge and credibility are pretty important to me. So fair. Sentinel, which defendant founded in 2018, describes itself as a nonpartisan platform developed to classify and track inauthentic accounts and toxic trolls on Twitter to fight disinformation and targeted harassment on the platform. It reviews Twitter accounts it considers suspicious, including automated accounts known as bots and human-controlled accounts it calls troll bots, which it defines as accounts that exhibit toxic troll-like behavior, such as retweeting propaganda and fake news or engaging in repetitive bot-like activity. I mean, I noticed right away that a lot of that's fairly subjective. What is propaganda and what is fake news? Depends a lot in the eye of the beholder. So, okay. It then rates these accounts in a publicly available database is either normal, satisfactory, disruptive, or problematic, and tracks the respective activities daily. Bot Sentinel solicits donations on its websites and has been paid by clients including Meghan Markle, Pete Buttigieg, and Amber Heard. Between July 20, those guys got ripped off, man. That's a bad deal. I don't know why anyone paid this guy. That's just a bad deal, but okay. I mean, people can be fools with their money. It's definitely legal to be foolish with your money, so okay. Between July 2020 and July of 2022, newspapers articles cited Bot Sentinel research in reporting that numerous Twitter accounts have been created specifically to target Amber Heard and her supporters with hateful comments and threads. I found a lot of that to be very wanting on a lot of levels. Heard paid Bot Sentinel for a report she found was subjected to one of the worst cases of cyberbullying during the trial. Then right away you spot the problem, right? Heard paid Bot Sentinel for a report, and the report said that she was subject to one of the worst cases of cyberbullying? What are the odds? What are the odds? If you just want to pay me to tell you what you want to hear, I'm amenable. Yeah, Amber Heard, you have the worst case of cyberbullying I've ever seen in my life. Please pay me. In September 2022, defendant and Bot Sentinel turned their attention to plaintiff and other law tubers who had streamed the trial. The law tubers, despite their diverse political views and backgrounds, were virtually unanimous in the opinion that Heard was not credible in the defense against Depp's defamation claims. Yeah, that didn't help. We definitely had our differences of opinion along the way, especially at the beginning, where I perhaps notably was part of the small minority of people who are like, this Depp thing isn't really doing much for me. And Depp, his testimony isn't particularly persuasive to me, and I see problems, right? But then Heard took the stand and opened her mouth. That went a long way to creating greater unanimity in the group. So before Heard opened her mouth, there was much more division of opinion, including from me. After Heard opened her mouth, less with the division. So yeah. Throughout the personal Twitter account, defendant demanded that YouTube delete some LawTuber accounts for troll-like behavior he deemed inappropriate, including spreading propaganda and fake news. Again, like you're dealing with a group of lawyers, and they're all lawyers, and they're commenting in an area that they have some professional expertise in, and apparently we're spreading propaganda and fake news. I literally don't know what that is. I don't even know hypothetically what he's referring to at this point, except news I don't like. But okay. On or before September 19th, Bot Sentinel rated Plamp's Twitter account as disruptive. A badge of honor, to be sure. On September 17th of 2022, defendant posted numerous tweets about Plamp, some of which he later deleted, in which he questioned Plamp's credentials. For example, he stated he couldn't tell if plaintiff was a legit lawyer or just a social media lawyer, and he could not find plaintiff in the database where he claims he practices law, or find the news article that plaintiffs claim to be featured in. Yeah, I don't know how they do it in New York, but for the longest time, you wouldn't have been able to find my information in the database for lawyers, because Virginia, unlike Texas, made it optional. And I didn't particularly want to be listed in the database. Just a personal preference thing. I was happy doing my thing. I didn't need to be listed in the database. And there was actually people who had made that mistake before. It's like, oh, he's not in the database. He's not a lawyer. I'm like, look, guys, if you look at the Virginia page, it says right in red. It says it right in red type, like that. It's not necessarily all inclusive, but they can't read, but that's okay. But Texas doesn't make it optional, or at least they didn't seem to make it optional. So when I became a Texas lawyer, I was like, I'll make my Virginia license information public too, because why not? At that point, so but yeah, so. Even if he were a legit lawyer, I'd wonder, hey, wait a second, is New York one of those states where maybe you don't have to put your name in the database? Because maybe it's optional. I don't know. Virginia was optional. So, yeah, just saying. He tweeted, there's no history of plaintiff practicing anywhere. Maybe the name isn't his real name. Also, I'll take a note here that practicing law doesn't necessarily mean that you're in court. So if you're trying to determine whether someone's a real lawyer by whether their name has ever appeared in a court filing, well, that doesn't really get you all the way. There's a lot of lawyers who don't do court filings. There's a lot of lawyers who do things outside of court filings. Court is part of the lawyer's trade, but definitely not all of it. So, if you can't find any record of court practice, that doesn't mean that they're not practicing law. Just FYI. The following day, defendant conceded that plaintiff was a lawyer and shared record of his status as a New York attorney. He also admitted that when he made the earlier claim about not being able to find a record of him practicing law, he already had the information, but was waiting for someone else to tweet it so he wouldn't be accused of inappropriately sharing his real name on social media, which sounds suspiciously like an admission of a knowing falsehood, which is a problem. Right? It's like, I knew it was wrong, but I said it anyway. In the same tweet in which he admitted plaintiff was a fact and lawyer and had been a police officer, he insisted plaintiff was never a prosecutor's claim, but he later admitted that this too was not true. Bouzy not so good on fact-checking himself. Defendant made statements accusing plaintiff of criminal conduct or suggesting that he had engaged in criminal conduct. He tweeted that plaintiff had bragged to his YouTube followers about illegally obtaining defendant's social security number. He called plaintiff a grifter and professional liar and suggested that plaintiff had used donations from his followers for this legal action to make himself and his lawyer richer. What? He also accused plaintiff and others of starting a coordinated smear campaign against plaintiff Sentinel. Well, I mean, you kind of did that on your own on that one because, your work is not very good. And sort of what you're trying to do, it's very subjective at best. More seriously, on September 20th and 21st, defendant posted a series of tweets stating that plaintiff had admitted in a video that he planted evidence as a cop, which, no, and knew when cops brought suspects in with bogus evidence when he was an ADA. Because he's paying attention. Yeah. He tweeted a link to a video along with the initial statement describing it, and later tweets in which he debated the meaning of plaintiff's words in the video with other Twitter users, referenced the video by saying that he admitted to a felony on camera. No, that wasn't a fair way of reading what Nate had said, and I suspect that Bouzy knew that, which goes a long way to the defamation idea. It's like, if you're knowingly putting someone in a wrong light, you're into some defamation or false light kind of torts. On September the 21st of 2022, the plaintiff, through counsel, transmitted a letter to defendant demanding defendant cease and desist and defendant delete any defamatory tweets. Defendant later issued a series of tweets in response to the letter stating that he and Ben Sentinel will not comply with the demands and encouraging plaintiff to file the lawsuit. Defendant reiterated statements that plaintiff admitted they falsified evidence as a police officer in video with a link to the video. Defendant expressed amusement at plaintiff's lawyerly contention that plaintiff had a spotless record when he was a campus peace officer at the City University of New York. In still more tweets, defendant attacked plaintiff's character in other ways. He stated that plaintiff was the type that would insult Black women so he could fit in with his Caucasian peers, that he was not comfortable in his own skin, and then he attacked defendant to receive attention because he desperately wants to be relevant. That sounds like a lot of projection to me, to be quite honest. Defendant's Twitter account gained followers during the period in which he criticized plaintiff. Yeah, okay. Plaintiff filed this lawsuit October 28, 2022 in the Superior Court of New Jersey. The complaint asserts that defendant's statements described above constitute defamation per quad, which I just don't particularly like as a turn of phrase. It's just something that gets under my skin a little bit. I'm not sure why it should, but it does. Defamation per quad is simply the only alternative to defamation per se. It's one of them. If it's defamation, it's one of them. Defamation per se or defamation per quad. I don't know. I always find the per quad to be a little pretentious. Well, it's defamation per quad. It sounds like I'm about to, go to a benefit dinner in a tux at a Rhode Island country club somewhere. And I don't want to be there. That's what it sounds like to me. Defamation per quad, defamation per se, false light torque, and intentional interference with prospective events. Defendants timely removed the suit to court based on diversity jurisdiction. So it was filed in state court. We removed it to federal court, which, yeah. What? Wait a second. Yeah, but how was he able to remove it to federal court again? Because he lives in New Jersey, right? So isn't that an exception to the diversity requirement? Okay, yeah, because how did you remove it to federal court? Huh. Okay, I'll ignore that and press on. An adequate complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. This rule requires more than labels and conclusions, and formulaic recitation of the elements of cause of action will not do. Factual allegations must be enough to raise a right of relief above a speculative level. A claim for relief must be plausible, and a complaint will not survive a motion to dismiss if the well-pled facts do not permit the court to infer more than a mere possibility of liability. Okay. When considering a motion to dismiss, the court must accept all factual allegations as true, construe the complaint in the light most favorable to plaintiff, and determine whether, under any reasonable reading, the plaintiff is entitled to relief. That sounds about right. Yeah, they're in different states, but he lives in New York at the time. Nate lives in New York. Bouzy lives in New Jersey. This was filed in a New Jersey court, right? And then removed to New Jersey federal court by the defendant. Hold on. Hold on. Let me see if I can find the relevant rule. District courts, removal from state court, removal of civil actions, non-removable actions. All right, hold on. All right. 28 U.S.C. 1441, removal of civil actions. Except as otherwise provided for by an act of Congress, any civil action brought in a state court of which the district courts of the United States have original jurisdiction may be removed by the defendant or defendants to the district court of the United States for the district and division, embracing the place where such action is pending. So you can do it unless you can't. In determining whether civil action is removable, citizenship of defendant sued under fictitious name shall be disregarded. A civil action otherwise removable solely on the basis of jurisdiction of 1332A. Town may not be removed at any interest in property. That's not right. Upon removal, actions of foreign states, multiple jurisdiction. I feel like there's an exception if it's the state in which the defendant lives. I'm not hallucinating some part of US code, am I? As I reach into the back parts of my brain and try to be like, wait a second, it doesn't strike me as quite right. Nate could have sued in federal court in the first instance, but having sued in state court, can the defendant remove it to federal court in the state in which he lives? Yeah. Forum defendant rule. $1441B. Civil action otherwise removable solely on the basis of 1332A. Is this 1332A because it's diversity of citizenship? Come on, don't make me sign to Westlaw. Just give me the damn section. 28 USC 1332. Yeah, so 1332A is dealing with diversity of citizenship. All right. And then 1341 says, 1341 A2 provides, may not be removed if any of the parties in interest properly joined and served as defendants. Removed if any of the parties in interest properly joined and served as defendant. Yeah. No, yeah, I think I'm right. I didn't hallucinate this, I don't think. Okay, something is wrong here. Okay, there's something wrong here. I knew there was a rule in the back of my head. Okay, it's called the forum defendant rule. All right, I figured it out. Yeah, so how did we remove it to federal court? So 1441 is removal of civil actions. 1441A, except as otherwise expressly provided for by an act of Congress, any civil action brought in a state court of which the district courts of the United States have original jurisdiction may be removed by the defendant or defendants to the district court of the United States for the district and division embracing the place where action is pending. So basically, if the plaintiff could do it, the defendant can do it, unless subsection 2, a civil action otherwise removable solely on the basis of jurisdiction under 1332A, which is diversity of citizenship, of this title, may not be removed if any of the parties in interest properly joined and served as defendants is a citizen of the state in which such action is brought. So that means you can't remove it. So Nate might have been able to file it. Nate might have been able to file it in federal court in the first instance, because Nate could have filed it in federal court under 1332, right? So Nate could have filed it under 1332 because, hold on, because yeah, so Nate could have filed it under 1332, diversity of citizenship, right? The district court shall have original jurisdiction of all civil actions where the matter of controversy exceeds the sum of $75,000, exclusive interest and costs, and is between citizens of different states, which he is, right? So Nate is a citizen of New York. Bouzy is a citizen of New Jersey. Let's assume that this is a civil action for greater than $75,000, because otherwise this doesn't make any sense. So we're under 1332A. So we can file this in the first instance in federal court. So Nate can file it in federal court, but Bouzy can't remove it to federal court because under 1441, right? Under 1441, which deals with removal of civil actions as opposed to the filing of civil actions. And this is why it's important to remember which rule you're under, right? So for the removal of civil actions, right? Then subsection A, except as otherwise expressly provided for by an act of Congress, any civil action brought in a state court of which the district courts of the United States have original jurisdiction may be removed by the defendant. So if Nate can do it, Bouzy can do it, unless subsection 2, right? Unless, because this is removal based on diversity of citizenship in subsection B. So this is subsection B, removal based on diversity of citizenship. Subsection 2, a civil action otherwise removable solely on the basis of jurisdiction for diversity of this title may not be removed if any of the parties in interest properly joined and served as defendants is a citizen of the state in which the action is brought, which means Bouzy can't take it to federal court. So how'd we get in federal court? Okay. All right. All right. That was a very, very long tangent because I'm like, wait a second. This doesn't make sense. You said defendant removed it to based on diversity. I'm like, no, he didn't. No, he didn't. Yeah. But apparently he did because we've got a decision from the district court. So I guess that the only logical conclusion is that Nate didn't raise the objection. Which, okay, I guess the only reasonable conclusion is Nate didn't raise the objection. So okay, so maybe Ron missed something. Maybe Ron missed it. Did Ron miss something? All right. Anyways, pressing on with the decision for the moment, which is why you guys came here, rather than a esoteric exploration of the finer points of diversity citizenship. All right. Where was I in this whole thing? I've completely lost my place. We read that. All right. Defendant timely removed this suit to court somehow based on diversity, even though he literally can't, but he did it anyway. Defendant subsequently filed the instant motion to dismiss, and parties have completed briefing. Yeah. An adequate complaint must be a short and plain statement of the claim showing that pleader is entitled to relief. The rule requires more than labels and conclusions, and formulaic recitation of the elements of a cause of action will do. Factual allegations must rise to the level above speculative. A claim for relief must be plausible, and a claim will not survive a motion to dismiss if well-pled facts do not permit the court to interfere more than a possibility of defense liability. When considering on a motion to dismiss, a court must accept all factual allegations as true, construe the complaint in the light most favorable to plaintiff, and determine whether, under any reasonable reading of the complaint, a plaintiff must be entitled to relief. However, the tenet that the court must accept all true allegations in the complaint is inapplicable to legal conclusions, because of course that wouldn't make any sense. Of course you're not entitled to your legal conclusions. That would be dumb. Determining whether allegations in the complaint are plausible is a context-specific task that requires a reviewing court to draw on judicial experience and common sense. Okay. All right. At the outset, the court decides which state laws govern the substantive issues in this case, using New Jersey's choice of law rules. That's very typical, right? So you use the choice of law rules of the forum state to determine which rules to apply. That is the standard rule. So we're in a New Jersey court, federally, I guess, but it doesn't matter anyway, because actually, for the purposes of the exercise, we're kind of not in federal court because we're using a state law to govern the issues of choice of law. So even though this is a federal court, let's pretend we're a state court, because that's basically what that means, right? The court decides which state laws govern. So we're going to go look to New Jersey law, like I'm a New Jersey state court. So I'm in a New Jersey state court now. Fine. The finer points of Erie chill the bones of every law student or lawyer who's in this stream. I just need to say the word Erie. New Jersey courts apply the tort law of the state with the greatest interest in governing the particular issue and generally follow the restatement of laws. Pursuant to Section 150 of the restatement, entitled Multi-State Defamation, when a person claims to have been defamed by aggregate communication, such as a newspaper publication or television broadcast, which is aired in more than one state, courts should apply the law of the state where the person is domiciled at the time if the matter complainant was published in that state. That sounds right? This is what we call the situs of the injury. So we're trying to determine where the bad thing happened. That's situs. You would say the site of the injury, but we don't call it site of the injury because we are lawyers. So we call it situs because we're all fancy over here. All right. So we have to figure out where the bad thing happened. All right. So where did the bad thing happen? Well, we're dealing with an intangible harm. Defamation is intangible, as opposed to a car wreck where the car wreck, happened at a place. Car wreck, physical. Defamation, not so physical. It's ethereal. Okay. So in trying to determine where the bad thing happened with the ethereal, we can look to the place of domicile if it was at least published there. So if it was at least published there, and this is an aggregate harm case, then we're going to determine the situs of the injury is where you live. This may sound vaguely familiar from our discussion when we were talking about this issue a little bit with Nick, for example, and Montegraph, right? Because we had a very similar idea about why would we bring in Montegraph's home state law into Nick's court. And the idea would be exactly the same, right? Intangible harm, globally occurring. The situs of the injury is Montegraph's home state, was the idea. So the idea should sound familiar. The comment explains that the reason for this are that the rules are designed to protect a person's interest in their reputation. Makes sense? The place where you live is presumably the place where your reputation is most pronounced. Thus, a state other than the state's plaintiff domicile may be that of a most significant relationship if the state is where the defendant communication caused plaintiff's greatest injury to his reputation, where the plaintiff is better known. So the rule is not absolute, like all good rules in law, which is why it depends. Right? So can it be some other state other than which you live? Yeah, it could be, because this is all based on a presumption that, the state in which you live is the state in which you were best known, but maybe not so much. So if you can provide a better idea, maybe that state, as we try to figure out which state laws to apply. We can only pick one. We can only pick one state law, so we got to figure out which state is best state. And we're going to go with the state in which Nate lives at the time. Sure. Plaintiff is domiciled in New York and does not assert the defamation statements, which were published globally, caused greater injury in New Jersey than New York. Makes sense. I mean, that could be true in some case, but not here. Yeah, that makes sense. Plaintiff concedes the injury was suffered nationwide and does not have any special connection to New Jersey, while New York is the state of his residence and the place where he practiced law and worked as a police officer and prosecutor. Thus, New York. I'm comfortable with this. This makes sense. I like this. This is fine. Right? So we're going to pick a place that applies. How about New York rather than New Jersey as the place that is most operative to Nate? And we're a New Jersey court applying New York law. Actually, it's even a little bit worse than that, because we're not even a New Jersey court. We're a federal court that just happens to be located in New Jersey that's applying the New Jersey state court now. So New York federal court, which was pretending to be New York state court, or actually New Jersey court. Yeah, so New Jersey federal court, which was for a moment pretending to be New York state court, is now going to pretend to be New York state court as we move around. I love it. I love so very much as we get to put on different hats, right? So I took off my federal hat, I took off my federal New Jersey hat and put on my state New Jersey hat, and now I've taken off my state New Jersey hat and put on my state New York hat. I love it so very much. This is why law gets complicated, and this is why I think it's fun. All right. Because New York law applies here, plaintiff's fault-like tort claim is dismissed with prejudice, because since neither a false light claim nor any other common law privacy tort exists in New York. Okay, fine. So having determined that New York law applies and having determined New York does not recognize the false light tort claim of cause of action, the claim goes bye-bye. Okie dokie, New Jersey would have recognized it, but unfortunately, we're not in New Jersey. Or we're going to at least pretend we're not. We're in New York. So since New York doesn't recognize it, I'm not going to recognize it. Fine. Plaintiff does not dispute the fact and only seeks to blame the claim under New Jersey law. Plaintiff briefly argues the same underlying facts support defamation by implication under New York law, but does not assert that in the complaint. And A, for reasons explained below, the complaint lacks sufficient facts to state a defamation claim. Okay. Did we move from false light into defamation in the middle of the paragraph? This is slightly confusing. Did we move from one cause of action into another cause of action in the middle of the paragraph? Okay. As to yeah, we kind of moved. This is a little sloppily written. These last two sentences really don't belong in this paragraph. The court starts talking about defamation for some reason in the middle of the analysis about false light. So bad court. These last two sentences don't belong here. You're confusing things. Defamation is making a false statement that tends to expose a person to public contempt, hatred, ridicule, aversion, or disgrace. Defamatory statements expressed in writing are referred to as libel. A claim for libel in New York has 5 elements, which are the same everywhere, but we're going to phrase them slightly differently from place to place because we can. A written defamatory statement of fact concerning the plaintiff, publication to a third party, fault, falsity, and damages. Wow, it's the same thing for defamation everywhere, in slightly different order with slightly different words, but it's the same thing. Since falsity is a sine qua non of a libel claim, ooh, fancy words, and since only assertions of fact are capable of being proven false, a defamation or libel action cannot be maintained unless premised on assertion of fact. Right. It has to be false. Opinions can't be false. Opinions can be wrong and idiotic, but they can't be false. So, if it's not a fact, then it can't be false. And if it's not false, then why are we here? Statement of opinion is not actionable, no matter how offensive. However pernicious an opinion may seem, we depend on its correctness, not for consciences of judges and juries, but on competition of other ideas. Kick ass. The only type of opinion that's actionable is one that implies it's based on facts which justify the opinion, but unknown. Yeah, because at that point you're communicating the facts, even though you're not. Right? So the very fact of the opinion, implies implies the existence of the fact, and you're communicating the fact through the opinion, which is what defamation through implication is all about. Right? So an example might be something like, in my opinion, person X is, I don't know, a thief. In my opinion, person X is a thief, right? The fact that my opinion, it says it's my opinion, but it implies that I have access to information that would form the basis of that opinion, right? It implies that I'm aware of incidences that would suggest the person is a thief. So saying, in my opinion, person X is a thief doesn't necessarily get you home, because you would assume, presumably, that I have information and facts that form the basis of that opinion. Therefore, I'm communicating the facts through the opinion. And that's the idea. Stating that accusations of criminality would not be actionable if the facts on which they're based are fully accurate and set forth. The accusation is merely a personal surmise built upon the facts. So even if my opinion is wrong, as long as I give you all the facts in the statement, nothing actionable, right? So if I tell you everything there is to know, I saw person X go into the store. I saw person X go pick up an item from the counter. I saw person X take it to the counter. I saw him pay for the item. I saw him walk out with the item. Based on this information, in my opinion, person X is a thief. And right about now, you realize that my opinion is full of shit, because nothing I said could possibly lead me to that opinion. But I told you everything. So there's no harm. You just realize that my opinion is shit. Because it's baseless. It's like, well, geez, well, everything you describe sounds like a lawful transaction to me. So I don't know what you're talking about. Sounds okay to me. Yeah. All right. Whether a statement is a fact or opinion is a question of law that turns on whether a reasonable reader could consider the statement to be conveying a fact. As always, how do we determine this? Well, it's based on the reasonably prudent person, don't you know? The reasonable man test makes an appearance yet again. The reasonable man test is best test. How do we know? The reasonable reader. Who is the reasonable reader? It's just the reasonable man. It's always the reasonable man. It's forever the reasonable man. The reasonably prudent person of ordinary, normal, common intelligence, the reasonable person that sits on the bus and travels to and fro. That guy. What would he think? The analysis depends in large part on the context in which the statement is made. Well, yeah, duh. Rather than sifting through communication for the purpose of isolating and identifying assertions of fact, the court should look to overall context, including forum, to determine how a reasonable reader would view them. Okay, that makes sense. And we've discussed this many times in defamation, right? A statement in isolation that appears to be a statement of fact may not be a statement of fact at all when understood in the broader context of everything else I'm saying. So if I say person X is a thief, that sounds suspiciously like a statement of fact. However, it's obviously not, because even though I literally just said the words just now, person X is a thief, literally said the words, it's not a statement of fact, because in the context of this entire monologue, it's an exemplar. It's an illustration. It is not a statement of fact, because you're all not complete idiots, right? I gave you an example of something for an illustrative purpose. It was not intended to communicate a fact. You're not that dumb. And even if you are, the law won't let you be that dumb. So a statement of fact that appears to be a statement of fact may not actually be a statement of fact based on overall context. And the exact same thing is true for a statement of opinion. Because a statement of opinion, like, in my opinion, person X is a thief, well, based on that statement alone, or based on other things I'm talking about, that might be a statement of fact. Although in this case, it's not, because once again, it's an exemplar. But, yes, context matters is basically what this boils down to. Context matters. You got to understand the thing in light of the entire thing. Great. $5 from Jason says, this is written by a clerk or judge. Seems a little bit confusing. Well, there was the two sentences at the end there that seemed a little misplaced, but we'll press on. Where were we? Taking into context to account, the New York Court of Appeals has held statements made at a public hearing were not actual because reasonable listeners come to a public hearing with expectations the speaker is airing a layperson's opinion, and because a person who's defamed at a public hearing has a remedy of self-help. Also, at specifically a public hearing, you could go one step further and suggest it's a privileged statement. Because the term public hearing suggests governmental communication. And I'm talking to the government, right? So it goes to that whole right to petition thing, right? For redress of grievances, not just freedom of speech, which is a First Amendment right, but also the right to petition for redress, and also the right to communicate lies, because you have a right to speak falsely. And in this context, I'm speaking specifically to the government. So maybe there's an idea that, maybe it's a privileged context. So all that too. Also, there's at least a arguable difference between a statement that's made, for example, in the middle of a comedy club set versus, on a broadcast, because people understand the context of it differently. So the same words might be understood differently depending on the context of when it's said. I mean, maybe there's an idea there that could make sense. So the forum, so the context might not be only understood as the words I say, but also the form in which I say it, or the method of my delivery of saying it. So the exact same words in the exact same order may or may not be defamatory based on the form or the tone or some other aspects of it potentially, because it feeds into the overall context. Okay, there's an idea there that maybe that could work. All right, let's see what else we got. All right, so we talked a little bit about a public forum. Courts applying New York law, mindful of the First Amendment, should be reluctant to employ their powers to correct errors uttered in a give and take of live public debate when they believe there's reason give and take itself can adequately, more appropriately remedy wrong. And also, incidentally, we've seen similar analysis in, for example, presidential debates or governor debates or senatorial debates. We've seen some of the same analysis because of that. So there is an idea, at least partially, that the venue might matter. All right. When plaintiff is a public figure, the First Amendment requires that the person demonstrate the defamatory statement was made with actual malice, that is, with either knowledge of false or reckless disregard. Great. An otherwise private individual who is not a household name may be a limited purpose public figure if he's taken an affirmative step to attract public attention. That case law needs to be revised quite a lot, in my humble opinion. If he's taken an affirmative step to seek public attention, the problem is that's coming from a 1976 opinion. It was a little bit harder and required a little bit more deliberation to seek public attention in 1976 than it does today. So 50 years later, we may need to revise this. But yeah, this is also why I'm hesitant personally to call someone a public figure, because all this language is old. All this language is old. And I'm like, well, I don't know if it's still applicable. All right. The actual malice inquiry is a subjective one, focusing on the state of mind of the publisher. Sure. Plaintiff is required to show actual malice because he is a limited purpose public figure. He pompously sought public attention and followers by creating YouTube and Twitter content on matters of public analysis, including analysis of Depp Heard trial and criticisms about Sentinel. Videos of his YouTube channel, which was created to make law more accessible, has been viewed more than 27 million times. All right, yeah, so, and then they say, finding an individual who posted political videos on Facebook was a limited purpose public figure. Yeah, this is where I question the law. Not as much the court's analysis, but this is more where I question the law. I have a problem with this as a matter of law. I think we need a revision. Saying that Nate purposely created videos on YouTube and Twitter on matters of public interest is kind of descriptive of a lot of people. Especially if you view it outside of including, for example, Depp Heard or criticism bot Sentinel. There's a lot of people on TikTok, Instagram, Twitter, YouTube, Facebook, everything else, who are injecting themselves into the public sphere constantly. Now, it's true that Nate has been viewed more than 27 million times, but that doesn't actually matter. And the court wants to confuse you. The court wants to confuse you, or I think they're trying to confuse you, and they hope that you don't notice, because they're like, oh, videos on his YouTube channel have been viewed more than 27 million times. It must be the 27 million times, but it's not. It's not, because they said earlier, they told you what the standard is. An otherwise private individual who is not a household name may be a limited purpose public figure if he's taken an affirmative step to attract public attention. This is one of those moments that every word matters. The 27 million times is irrelevant because the standard isn't based on success. What is the standard? They told you. They told you, just pay attention. If you've taken an affirmative step to attract public attention, success doesn't matter. All that matters is that you took the affirmative step. So this sentence from the court that his videos have been viewed 27 million times is some meaningless garbage. And I think the court might be doing it deliberately to confuse you. They want you to see, 27 million times, he's a public figure. But it doesn't matter. It doesn't matter, because what matters is what the court even told you in the immediately preceding sentence what mattered. In the immediately preceding sentence, they tell you what mattered. He purposefully sought public attention and followers by creating YouTube and Twitter content on matters of public interest. He sought public attention. He took a step to attract public attention. The 27 million followers is just a nice bonus. But it's not the standard. It could have literally been one. It could have been zero. It could have been zero. It could have been literally no one has seen it. But does that matter? It doesn't, because the standard is if you took an affirmative step to attract the public. The fact that the public didn't notice, who cares? And my problem with this as a matter of law is, again, in 1976, it was a little harder to take an affirmative step to seek public attention. You had to try a little bit in 1976 to take an affirmative step to attract public attention. Well, that's going to require some effort, in 1976. In 2023, not so much. Literally every single one of you is commenting in this video that every single one of you participating in chat is commenting. Are you taking affirmative steps to seek public attention? Do any of you hope that the comments you're typing in chat might be noticed by anyone else in chat or noticed by me? Are you typing your comments in chat with the expectation or hope that your comments in chat might be noticed? Are you trying to attract attention? Are you trying to inject yourself into a public discussion? Are all of you limited purpose public figures now? Because I'm not sure you're not. And this is where I have some problems with the law. All right? This is where I have some problems with the law. Because if you apply this standard, it's a little bit unclear in this day and age that there isn't anyone who isn't a public figure. Like, have you ever posted on social media ever? Was your social media account limited to only your friends and family? Did you create a social media account ever where it was open to the public and posted things with an expectation or thought that maybe people in the public would see it? Are you a limited purpose public figure? So this is where I have some problems with this language as a matter of law, because this is some bullshit that needs to be revised. Just saying. Just saying. So this 27 million time language is some bullshit. I'm on to you, court. I'm on to your schemes. Plaintiff's defamation claims fail because it is not sufficiently alleged defendant made any false statement of fact with knowledge it was false or reckless disregard for the truth. Crucially, overall context in which the alleged defames occur here is Twitter. As parties are well aware, given both have engaged in calling out mistruths on Twitter, which is presumably another way of saying falsity, Twitter is a public forum, which a reasonable reader will expect to find many more opinions than facts. Okay. So I suppose we're comparing Twitter unfavorably to, for example, a newspaper. Okay. New York courts have consistently protected statements made in online forums as statements of opinion rather than fact. Noting a tweet does not give the same impression of truth as a newspaper article. Okay. I don't know about that. This is a slightly. I understand the point that the court is trying to make, but it feels a little uncomfortably subjective, and it feels a little bit open to perception of people at any given time. So they say Twitter is a public forum where a reasonable reader will expect to find many more opinions than fact. Assuming that was true in 2015, by the way, which is apparently when this citation is occurring. Is that true today? Is it equally true today? Is the perception of Twitter as a forum for accurate information better or worse? And should the perception matter? It almost implies that online forums by necessity are lawless wastelands where there is no law, and you better, arm up with your 6-shooter because you'll have to keep your own peace. And is this true because Twitter is, compared to newspapers, a relatively modern medium? It strikes me as a little bit elitist, maybe. It strikes me as a little bit elitist because if you go far back enough, you can find statements like this about the movie industry. Because there was a time and a place when the movie industry was brand new, just getting started. And, initially it wasn't taken very seriously as a medium. And then, it got established for a while and it got a little bit more serious. And then this thing called television came along. And if you go look at statements, until pretty recently, to be quite honest, television wasn't taken very seriously as a medium either. The idea of like a serious Hollywood actor deigning to participate in a TV show, clutch my pearls, I would never lower myself to such things, right? Like, so, when they invented movies, that was the thing where it's like, I'd never lower myself to such low lights. And then when they invented TV, it was the same. And then when they invented video games, it was the same. And then when they invented social media, it's the same. So maybe 50 years from now, if Twitter or its successors is a thing, maybe it will be the old established media. It'll be the old established media, and they'll get to look down on some new form of communication that's just being invented. So it feels a little bit elitist. It feels a little bit like, Twitter is the kids' table, which feels just like a recycling of basically everything that's been said about every new medium that's ever been invented ever. It's just like, this isn't the real one, When they first invented the Gutenberg press, I'm pretty sure they were looking down on it. The Gutenberg press? Oh my God, this abomination without the hand engraved pages and the gilding and the fine colorized details made by the monks. This trash medium. What do you call this? A book? A book? Who would ever lower themselves to read such scurrilous thing? All the real people know that this best stuff is written by the monks in the calligraphy with the colorization. I'm pretty sure they were looking down on the Gutenberg press when it was first invented. So it's basically everything old is new. It's basically the same argument that's been had basically for the last 500 years. Don't you know the Gutenberg press? They're even writing it in English. Oh my God, the English. Oh no, what happened to Latin? Who will think of the children? Woof. Woof. So it feels a little elitist and a little out of touch with the history of such things. Moreover, Twitter is a forum where a user in the same setting with the same audience has immediate opportunity to air a competing view, and thus generally remedy any defamation with self-help, which I suppose is the court really just giving up the ghost and saying, hey, that implication I said earlier, or that implication that Uncivil said earlier about how the court is really saying this is the Old West and bring your six-shooter, that implication I was saying was an implication about 3 sentences ago? Well, the court's now just saying it outright. So what is the court saying? Are they saying this is a lawless land? It's like, yes, that's what the court is saying. They're saying it is a lawless land and help thyself. Super duper. This is especially true here where the plaintiff was an avid user of the platform with many followers and thus had significantly greater access to challenge of effective communications than his peers. Is it really based on like subscriber count? Also, what is many followers? Just out of curiosity, what is many followers? Is that like some sort of legal threshold? Does Nate have many followers? I guess he must, because apparently this is a legal finding from a court. So I guess Nate must have many followers. Many compared to what? I suppose is, does he have many followers? Is it compared to Bouzy? Is that it? Is it that is a issue of who has more followers? Is it a dick measuring contest? Is that what it boils down to? Is it who can afford the most barrels of printer ink? Is it don't get into a fight with the guy who buys ink by the barrel? Is that what we're doing? And so because Nate has more barrels of printer ink, therefore he can help himself, so he doesn't need the court? So it's a popularity contest? I don't know, man. Something about this analysis strikes me as a little bit odd. It feels pretentious. It feels elitist. It feels erudite. It feels like the plebes can take care of themselves. I mean, it is a federal district court, though. So almost inherently, because it's a federal district court, the judge necessarily has a superiority complex because he's been elevated to the on high. So I guess it isn't so much a surprise that he has disdain for the plebes, because he's been elevated to the priestly class and the rest of us can suck it. So, okay, well, fine. Several defendants question plaintiff's credentials, including tweets regarding whether plaintiff was in fact an attorney and former prosecutor. Among these, the only one that a reasonable reader might view as statement of fact is defendant's statement that plaintiff was never a prosecutor. However, plaintiff fails to plead facts showing the defendant made the statement with actual malice. So none of the tweets concerning plaintiff's credentials are actionable. But you showed other statements were knowingly false, so you can't even get to discovery about it? Okay. Defendant's tweets questioning whether plaintiff was a lawyer are protected by First Amendment speech because a reasonable reader would view them only as opinions, and the facts upon which they were based disclosed, so readers can easily judge the facts for themselves. Defendant's first statement inferring the plaintiff was not a real lawyer, well, I don't know if it's so much inferring as flat out saying it because it's in quote marks, but okay. That's a neat trick. It's now an inference when you say things explicitly. Also, wouldn't the correct word in that sentence be implying, not inferring? Court, shouldn't that be defendant's first statement implying? But you don't want to use the word implying, do you? Because if you use the word implying, you'd have to concede the idea of defamation by implication. So you can't use the word implying. The defendant doesn't infer. The defendant's statement doesn't infer. You infer. The defendant implies. You infer. Do we understand how these words work? Right? When I make a statement, can't infer. If I make a statement, I imply. You infer. But he can't use the word imply. Because if he uses the word imply, he's conceding the idea of defamation by implication. So he uses the incorrect word infer. I am on to you, court. I am on to you. I am on to you and your linguistic tricks. I see you on the page. Was plainly based on the fact that he could not find plaintiff in a database where he claims he practiced law. And the tweet includes a link to the New York site. Plaintiff concedes that his name he used on social media was not his real name, so it was not false for defendant to say he could not locate defendant's bar number or find him on the attorney database. A number of defendant's tweets allude to the fact that plaintiff might not be using his real name on social media. Was there seriously anyone who thought that his real name was Nate the lawyer? I don't know if that's so much an illusion as just like him saying again. Was Nate alluding that he wasn't using his real name? Was that an illusion? Also, here's a shocker, by the way, guys. I know this will come as massive news to you, but prepare yourselves. My real name is not uncivil law. Okay. A number of defense tweets which provided the suggestion that perhaps maybe it wasn't his real name, or there was surely a reasonable explanation for why he did not appear in the attorney database, given the reader of these tweets even less reason to believe defendant was in fact when he suggested he was not a lawyer. Plaintiff alleges that the day after posting these tweets, defendant corrected the record after learning that Mr. Brody is in fact a New York attorney, but later explained in a tweet they tweeted some prior statements about plaintiff not appearing to be a lawyer knowingly and willfully. However, the tweet purportedly explains this is not so clear. Isn't that kind of a question of fact, though? If it's not clear? Okay. Defendant, referencing back to an earlier tweet in which he said there's no history of him practicing, and maybe the name he's using isn't his real name, stated he already had the information. The statement does not demonstrate the defendant knew at the outset that he's in fact a lawyer under a new name. So, Mr. Bouzy saying he already had the information is not an admission that he knew he was under a different name. Okay. As a matter of law, apparently, fine. Moreover, it's unclear what information he had. Assuming the information was plaintiff's real name, defendant's statement that he had no history of him practicing is still substantially true with regard to the social media persona he was apparently referencing. What? So, wait a second. Wait a second. There's no history of him practicing is still substantially true with regards to the social media persona he was apparently referencing? Okay. I have a question at this point. A question I never thought I would ask. But is uncivil law a lawyer? Because I'm a lawyer, but there's now a distinction between me and the persona. And I have to tell you that there is, in fact, no bar license anywhere that has the name uncivil law on it. So I am really confused now. I am really confused now. So this statement that there was no history of him practicing is still substantially true with regards to the social media persona. So now if someone says uncivil law isn't a lawyer, is that substantially true with respect to the persona because the persona isn't a lawyer? Presumably. Or is it? I honestly don't know at this point. I'm so confused. I honestly don't know at this point whether the persona has a law degree or not. Because apparently this is a question I have to ask. The court has now thrown me into a full-bore existential crisis. Okay, that's great. I suppose it's true that Nate the lawyer has never practiced law. I guess if we're drawing this distinction now, which seems like a really dumb distinction. I am so confused. I'm so confused. Okay. Uh, okay. This also gets into the interesting distinction between me and the persona, and the authenticity of the persona versus myself. Guys, we're gonna have a full book. We're gonna have to have a full bore, full deep dive existential philosophy discussion. Okay, what is the distinction between me and the persona? What is the distinction between me and the person that appears on camera? Who's speaking to you right now? I don't even know. I'm not even 100% sure who's speaking to you. Is it me? Is it the persona? What's the difference? Is it a matter of how close the persona is to me? I thought I was living pretty authentically. Do I even know myself? Am I ever really even myself? Even in my day-to-day life, as I move around the day, as I move around in the world, am I ever truly me? Because can I ever really be me? Do I even know myself well enough to be me? Who is me? Who am I? What is the nature of myself? Is it an act? Is it a simulation? How would I know the difference? All right. In the same tweet in which defendant admitted that plaintiff was in fact anyone who's coming to Anime Matsuri this weekend can meet I was gonna say meet me. You're gonna meet somebody. I'm not sure who it is. I'm not sure if you're meeting Uncivil Law. I'm not sure if you're meeting Kurt. Who will you be meeting? You guys will have to figure out for yourself who you're meeting, I guess. So I suppose the most authentic answer at this point to will you be at Anime Matsuri is I don't know. Great. That's great. In the same tweet in which defendant admitted that plaintiff was in fact a cop and became a lawyer in 2016, he added the plaintiff was never a prosecutor. This tweet included a screenshot of attorney detail report from the New York court website dated 2022 with blocks of text blocked out. A reasonable reader could believe defendant derived all state information about plaintiff's career history from the page, which was not all visible to the reader. And thus, defendant's statement that plaintiff was never a prosecutor was a statement of fact or an opinion based on undisclosed facts. The statement was false. However, plaintiff does not allege any facts showing defendant knew the statement was false at the time it was published or made it with reckless disregard for the truth. The complaint demonstrates defendant had some regard for the truth as he deleted older tweets with misstatements, and even in the same tweet containing the statement, he corrected some prior misstatements. Plaintiff alleges defendant ultimately conceded the falsity of the claims about plaintiff's background and credentials. Accepting the alleged facts as true, they do not establish defendant's actual malice at the time of publication. Defendant's tweets contending or suggesting plaintiff committed crimes are also statements of opinion, so they cannot form the basis of defamation. Defendant's tweet described plaintiff as a grifter, liar, troll, or participant in a smear campaign are clearly opinions with context, and non-defendant's tweets making the remarks imply they are based on undisclosed facts. Okay. Defendants' more direct accusations of criminal conduct cannot constitute defamation because they disclose upon the facts on which they're based. Okay, I guess. I suppose, yeah, I guess that's a reasonable conclusion, such as it is. Similarly, defendant's tweet stating the plaintiff bragged to his YouTube followers about illegally obtaining defendant's social security number contained a link to a YouTube video. Readers who were free to, and apparently many on Twitter did, reach different conclusions of where a plaintiff admitted in criminal conduct in the videos. I'm not sure that the court is right here because it does require a person to click the link for more context. And I'm not sure that's necessarily enough. I'm not sure that's the same thing. Like if I disclose you all the facts and then give you an opinion versus saying I gave the facts in an earlier episode, watch that, and here's my opinion. I'm not quite sure those are the same thing. This basically is implying incorporation by reference, which I'm not sure really quite works because it does put more of a burden on the listener to do more research, which isn't necessarily the same, right? It's like, it's me saying, here's something, and I said something in an earlier video or earlier thing or earlier book, but I have to go read the thing, and it's hard to do that. So a lot of people won't be bothered, and it puts more imperative. I'm not sure that trying to incorporate by reference here necessarily works. Okay. All right. Defendant's other tweets cited in the complaint, though offensive, are non-actionable opinions because a reasonable reader would not believe them to convey facts, especially in the broader context in which they're made. The party sparring on Twitter, which I think is sort of the court's ultimate conclusion at sort of the end of the day. I think the ultimate conclusion of the court is that Twitter is a lawless place and you're on your own. I think the ultimate conclusion of the court, the thing that this is all really grounded on, the thing that's sort of the baseline, the thing that's sort of the end game, the thing that's ultimately all boils down to is that the court doesn't have a lot of respect for Twitter as a medium. And the court thinks that, it's the sparring peasants and the plebes. And it is an uncivilized place where people go to fight and piss on each other. And there is no redress available. So it's the Twitter exception to defamation. It's a Twitter exception to defamation. You meet each and every element of defamation, but Twitter though. That's kind of what this boils down to, but Twitter, though. And I'm not so sure about that. Yeah. Plaintiffs failed to dispute that the claim for intentional interference with the prospective domestic business events is duplicative in the instant circumstances, merely arguing New Jersey allows such claims to proceed together with defamation. Plaintiff does not allege defendant interfere with any specific contract or binding business relationship, so this claim is construed as a claim for interfering with non-binding existing or prospective relationships. Stated claim based on inference with a non-binding relationship. The plaintiff must generally show defendant's conduct amount to a crime or independent tort unless they acted with the sole purpose of inflicting intentional harm on the plaintiff. Plaintiff has not sufficiently alleged the defendant's actions amount to a crime or tort, and the conclusory allegations that the defendant's actions are part of a campaign to call social media platforms to restrict, limit, or eliminate the ability to access, profit from publication on content, or insufficient to demonstrate defendant acted with the sole purpose of inflicting harm. The complaint itself alleges the defendant had other motivations for making false statements. He was offended by criticism of Heard and Sentinel. He wanted to promote himself and advertise Sentinel, and he wanted to attract followers and potential donors. What? Since when is motive relevant? What are you talking about? I am so lost. What are you talking about? Plaintiff has not sufficiently alleged defendant's actions amount to a crime or tort. And conclusory allegations defendant's actions are part of a campaign to cause social media platforms to limit, restrict, or eliminate the access or ability to profit are insufficient to demonstrate defendant acted with the sole purpose of inflicting harm. Since when does it have to be the sole purpose? Or really a purpose of any kind, to be honest. Unless the defendant acted with the sole purpose of inflicting harm. So you must show it's a crime or independent tort unless you acted with the sole purpose of inflicting harm. Really? Really? Sole purpose of inflicting harm. So as long as you have mixed motives, you're all good? That seems odd. That seems odd. So as long as I want to cause you harm and also make myself get more money and or make my own social media better, I win? And it's a C site, which, you know, because it says C, Carvel Corp, which suggests that the word C is usually an indicator that this is, what would you say? Kind of like a passing reference, right? It's not quite on point. It's not irrelevant, but it's not quite on point either. It's like a passing reference. It's sort of like an idea, maybe. So when you say the word C, it's like it sort of implies that it's kind of tangential, maybe. And so then you're saying this with an id, and then you also back it up with another C site, which isn't strongly encouraging. I'm half tempted to look this up and figure out whether the court is quoting this honestly, because I'm dubious. I'm dubious that the court is citing this and they're being honest about it. I don't think it says that. I think the court is pulling a fast one, is what I think is happening. And I think the court is hoping I'm not going to notice. I think the court's playing a little trick on me. And I'm very tempted to pull this and figure out whether or not that's true. We are getting to the end of this thing. Maybe I'll come back to it and pull it. Defendant has not sufficiently alleged that defendant's action amounts to crime or tort, and the conclusory is all part of a campaign to cause it, limit, restrict, or eliminate the ability, or insufficient to demonstrate acted with the sole purpose. By saying he has other motivations. Well, apparently that was a mistake. Apparently saying he had motivations beyond merely causing harm was somehow a mistake. That doesn't sound right. That doesn't sound right. For reasons set forth below, the motion is granted, dismissed without prejudice, and some other stuff dismissed with prejudice, 30 days, blah, blah, blah. All right. Let's pull the citation. Let's pull the citation and figure out if the court is being good court, because I think court is being bad court, and I want to call the court out on some bullshit. All right. All right. So what is this thing saying? So you're citing page 1103 in all of its glory. My kingdom for a page marker right about now. $188. Oh, it has two different citation formats. Now I have to find it with the right citation. Oh. All right, fine. Hold on. Do you have citations in the other format? I don't really want to read this entire case. You're going to make me read the entire case, aren't you? I refuse to be defeated. To hack into my own. Okay. Man, I need access to. I need it so I can see the right page numbers. I can already tell I'm going to be grossly disappointed by the time I figure this out. All right, hold on. Let me see if I can pull it up on Fastcase. There's a lot of effort just to call out the court, but they never said it was going to be easy, did they? Talk amongst yourselves. It's not going to give me the thing I want in fast cases either. No results. Come on. No results. Oh, there it is. Do you have citations for me in the correct format? You better. I will beat you to death. No. What did you look this up in that you got this format in? That's written with the wrong pagination in the reports I'm looking at. All right, fine. I'll read the whole case. I will not be defeated by you. We'll do it the hard way. We'll just read the whole case. You can't stop me. So it better be good. All right. Carvel Corporation versus Elizabeth Noon. Court of Appeals of the State of New York, 2004. Oh, Lord. Several franchises of the Carvel Corporation sue in federal court complaining of distribution are Carvel's product through supermarkets that compete with its franchises. Juries award damages to 3 of the franchises on tort and contract, and Carvel appeals to the United States Court of Appeal for the Second Circuit. That court has certified to us the question of whether the franchises have a valid tort claim for interference with respective economic advantage. This is the Court of Appeals. This is the highest court in New York. Okay, all right, fine. New York, please rename your court system. It's very confusing to me. It's very confusing to everyone. I think you like it that way. This is from the Court of Appeals of the State of New York, which is the highest level court of New York. Everyone else would call it the Supreme Court. What does New York call its trial level courts? The Supreme Court. I hate you, New York. You suck. Get a better system. Until early 1990s, Carvel's ice cream was distributed only through franchise stores, and Carvel had repeatedly told franchises it had no plans to sell through supermarkets. A decline in Carvel's fortune caused it to change its mind, and Carvel adopted the supermarket program. The program called for sales to supermarkets by Carvel itself and by those franchisees that chose to participate, which required franchisees to pay substantial license fee and upgrade their stores. Why? Most franchisees chose not to participate. From 1993 to 2000, the supermarket program grew rapidly, while many franchisees went out of business. The franchisees assert that Carvel's supermarket program was harmful to them in itself, and details of the program's implementation made it worse. Among the grievances were that Carvel sold to supermarkets at bargain prices and issued coupons to customers that Carvel would redeem from supermarkets but not franchisees, and the coupons were printed on bags that Carvel required franchisees to use in their stores. So you couldn't use the coupons at a Carvel store, but you could use it at a supermarket. Fine. They contend that Carvel's program was not consistent with customary practice and standards in the franchise industry. That seems logical. The franchisees claim both in contract and tort are illuminated by the written agreement. The agreements are of 2 types. The early agreement, known as Type A, includes a specific restriction on their right to compete with franchisees, providing that Carvel will not establish or license another person to establish a Carvel store within a quarter mile of the store on the same street. The Type A agreement contained other language, including reference to a unique system for production, distribution, and merchandising that franchisees interpret as prohibiting Carvel from implementing the supermarket program. Okay. The Type B agreements also contain the unique system language, but not the quarter mile restriction. They provide that the licensees granted franchise were non-exclusive, and the Carvel, in his sole and absolute discretion, could license other stores and could sell its products through the same or different delivery systems or other distribution channels. Well, I mean, that sounds a lot more clear for what Carvel wants to do. The franchise who signed these agreements had all received, before they signed into the agreements, an offer circular saying that they were free to sell through supermarkets. Other free franchises who took the case before us, Marcel and Noonan signed a Type A agreement, third Type B. Each agreement contains a New York choice of law clause, and it's not disputed that governs the claims. The two franchises who suffered the agreements were allowed to go to juries on the claim that they breached franchise. One of them, the Noonans, got a favorable verdict. All the franchises went to jury on the claim they breached the implied covenant of good faith and fair dealing and tortiously interfered with the existing or prospective business advantage. And all three got favorable verdicts. Only the verdicts for tortious interference are now our concern. Okie doke. The Second Circuit asks us the following questions. Under applicable standards for claims of tortious interference with respective advantage, did the evidence of franchisors' conduct in each of the three trials on review in the consolidated appeals permit a jury finding? We answer no. The franchisee's tort claim is that Carvel unlawfully interfered with relationships between franchisees and their customers. The franchisees do not claim the customers had binding contracts that Carvel induced them to breach. They only allege that by implementing a supermarket program, they induced the customers not to buy Carvel products from the franchisees. Okay? The juries have found that Carvel did so induce, and the question for us is whether that inducement was tortious interference. We conclude it is not because Carvel's conduct, which did not constitute a crime or independent tort, and was not aimed solely at harming franchisees, was also not the sort of egregious wrongdoing that might have supported tortious interference in the absence of such agreement. Independent on unlawful act or motive. Oh my God, I hate the court in Nate's case even more. So they take this idea from this case and they want to apply it globally when it's not really written that way. The court's overstretching the case. The court is overstretching. Right? So in Carvel's case, it wasn't a crime, it wasn't an independent tort, and it wasn't aimed solely at harming the franchise. But the court in Nate's case is taking that like one of those things is required when the court is simply noting their absence. The court doesn't seem to be saying, here is what would be sufficient. They're simply saying, here's some things that were lacking. Presumably, if any one of them are true, it would have been sufficient. But it doesn't seem like the way they're writing it, that because all three is absent, it's definitionally non-sufficient. So I think the Nate's court is stretching the language, which, to be fair, they sort of believe themselves because they gave it as a C site. So the court knows better. The court says, by saying that defendant who induced the breach of binding contract could be liable, even if defendant was engaged in lawful behavior, we imply the same was not ordinarily true when the complaint of only interference. It especially applies, if not a fortiori here, when the franchise complaint of interference not with contractual rights, but only existing or prospective rights. Under MPD, when a suit is based on interference with a non-binding relationship, the plaintiff must show defendant's conduct was not lawful, but more culpable. The implication is, as a general rule, defendant's conduct must amount to a crime or independent tort. As a general rule. Conduct that's not criminal or tortious will generally be lawful and thus insufficiently culpable to create liability for inference with prospective advantage. And then there's a cite to a cite, which they didn't give me. Such an exception has been recognized where defendant engaged in conduct for the sole purpose of inflicting intentional harm. And then there's a cite. I hate the court. I hate the court because it didn't cite the underlying case. It cited the case that cites the case. We're playing the worst game of telephone ever. See, yeah, it's undisputed that Carville's motive in interference with relationship was normal economic self-interest, one to reverse a period of business decline to make itself more public. It's not acting solely to hurt the franchise. We did not decide in Guard Life or NBT, and we do not decide today when the other exception to the general rule exists. Whether there can be instances of conduct which, though not a crime or tort itself, were so culpable that it could be the basis of claim. That's a question we leave for another day. Well, that's a question that apparently Nate's court completely ignored and pretended that was disposed of, and when it wasn't. So the court was playing a little fast and loose. I am on to you. I am on to you. So yeah, this decision basically boils down to but Twitter though. That's basically the too long didn't watch. If you want the too long didn't watch of this decision, the decision is but Twitter though. That's what this decision really is. Twitter is a lawless land where only the plebes and the third class passengers hang out, probably followed by dust clouds, and talk about the weather and growing corn. And, we, the aristocratic elite over here in our white tie, notice their japes with bemusement. And we cannot let them come to the esteemed high that is the district court and get relief. And that's what this decision is. I think the district court wears a frock coat in their spare time, possibly with a top hat and a monocle. They read the New Yorker and think of themselves as very sophisticated. I am pigeonholing the district court at this point. Let's see. Susan Wingington. Oh, her name sounds like old money too. Susan Wingington. She old money? She sounds like old money. Let's see. Born in Neptune, New Jersey, grew up with three brothers in a sports-oriented family with a pastor brother, graduated Norfolk State, Bachelor of Arts, Collier and William and Mary, 1987, law clerk, New Jersey Superior Court, Federal Judicial Service as a magistrate judge. Yeah. Okay. Okay. Well, that's all there is there. So I think Nate could raise the cause of action, and he could do it. He could re-raise it with a defamation by implication. And all he needs to do is convince the judge that Twitter is not a lawless land where the law does not apply. Ah, good times. So I can see why Nate or Ron might be frustrated by this decision, because the court all but concedes that Nate has all the elements. And then basically but Twitter though. So fine. This Twitter is a public bar, something like that. Something like that. I think the court. I think and the court. I think the court might have a point, but I'm not sure you can relegate all of Twitter this way. And she seems to think that because there's an opportunity for immediate redress, that there's no defamation and no harm, which feels like an issue of damages rather than an issue of liability. Because Nate's ability to respond and put out the truth would presumably mitigate his damages, potentially. But it doesn't eliminate Chris Bouzy's liability, right? So if the judge's point is that Nate, because he has this widely subscribed to Twitter channel, whatever that means, can get the real information out there and so basically forestall the harm, that just seems like that makes the damages go less rather than the case go away. And also the degree to which this is true of Twitter seems like a question for a jury too. Because maybe it is. Maybe that's an argument you can make, but is it true as a matter of law is another problem, right? The judge assumes it's true as a matter of law, but is it? I mean, maybe you could get a jury to believe this. I don't know. It's the reasonable man test. Ask a reasonable man. But as a matter for dismissal, right, as opposed to for summary judgment, is a little bit odd. So maybe you can make the argument at a trial that Twitter is, just the social media and it's the Wild West and nothing really matters and it's a place where insults go and it's a place of frivolity and light and japes. And so why so serious? Maybe it's an argument you can make, but is it an argument that's true as a matter of law? I don't know. That's true as a matter of law. Maybe you get a jury to believe that. I don't know, but yeah. Amber Heard was found liable for op-ed because she posted on Twitter. It specifically mentioned the tweet count as publishing the statements herself. It sure did. I guess Amber Heard didn't think of the Twitter isn't real defense. Maybe that, I don't remember that coming up in any of the appeal briefs that we read before the case got settled. I'd have to double check, but I'm not sure anyone thought of the Twitter isn't real defense. So maybe Amber Heard's team missed a trick. Wouldn't be the first time. Of course, Amber Heard's team did miss the biggest trick of them all. Amber Heard. This joke brought to you by Uncivil Law. Look at them. Can Trump use the Twitter isn't real defense? I guess. Yeah, that goes a long way to that. Yeah, I guess that goes a long way to Trump's criminal liability, hypothetically, because I can't help remembering that the complaint against Donald Trump mentioned Twitter a lot as part and parcel of the fact pattern. So maybe Donald Trump can try the Twitter isn't real defense. So it doesn't matter. Yeah. For someone in chat asking about membership gifts, I asked YouTube, by the way, and they said, and this is what they told me, I'm just telling you, that iOS devices cannot gift memberships. It's only on Android that you can gift memberships. So I don't know what to tell you. That's what they told me. They told me it's not a setting on my end. They told me that it's not something that iOS devices can do. You can't gift memberships on iOS. So I don't know what to tell you. So Just super chat normally or PayPal or something, because it's not a setting on my end and they told me to go away. This judge just set precedent for the defense. Well, strictly speaking, they didn't set precedent because it's a district decision, but still. I didn't know this was an option that you could go through. Apparently it is. Apparently you can try the Twitter isn't real defense. D. Canuck gifts 10 gifts memberships. Thank you very much. I'm thinking about going to the gym today. I went to the gym yesterday, though. And I do have class tonight. Maybe I'll try to squeeze it in. Thank you for the gift memberships, by the way. Thank you for everyone who helps to support the channel. Florida jury finds... Wait, this is 629. That's long ago. Oh my God. Why am I viewing old messages? Andrew Horowitz became a member earlier today. Thank you very much. K Tribe said I was awesome. Thank you. Christina Rain gifted a membership. Fiery Red Podcast has been a member for 8 months. Christina Rain has been a member for 24 months. Jason Lazat has given $5. Appreciate it. Thank you. B-Fish is fine. B-Fish sits right over here, right on top of my audio interface, and looks at me lovingly and lets me know it's all going to be okay. B-Fish lets me know it's all going to be okay. He sits right on top of my audio interface so that he's always within close reach, and he tells me he loves me. B-Fish is great. Any idea when the next trial will be? Not off the top of my head, no. B-Fish tells me that the best way to deal with the absurdity is just keep swimming. B-Fish has a point. All right, well, I'm going to sign off for now. This has been a much longer stream than anticipated, but thank you everyone for joining. As always, for those of you who will be at Anime Matsuri, someone fitting my physical description will be at Anime Matsuri. But who it is, a mystery. Because who even am I? Ugh. So yeah, there you go. That solves the problem. We will be at Anime Matsuri. There you go. That solves the problem. We will be at Anime Matsuri. That is, Kurt will be at Anime Matsuri. Uncivil Law will be at Anime Matsuri. We will be at Anime Matsuri. The royal we solves the problem. We will be at Anime Matsuri. We are looking forward to seeing you. We have been Uncivil Law Kurt. I hope you've enjoyed this program. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.